Hi, I'm Derek. This video provides information on the rules, procedures, and forms for the Supreme Court of British Columbia. There are many things you need to know if you have a case at the BC Supreme Court. In addition to understanding the law that applies to your case, you need to know about the rules of court, Supreme Court procedures, and the forms you need to use to move your case forward. The Court Rules Act contains a set of rules called the Supreme Court Civil Rules. There is a separate set of rules for family law cases called the Supreme Court Family Rules. These rules will guide you through your litigation. In essence, they are a roadmap for taking your case to court. In July 2010, the BC Supreme Court introduced new civil and family rules, which you can access from the link on the homepage of this website. The wording, requirements, and numbers of the court rules were significantly changed. We are referring to the new rules in this video. The rules are very important for several reasons. They provide guidelines for every step in the litigation process. For example, they tell you how you must serve your court documents on the other party, how to get documents from the other party, and how much time you have to examine the other party under oath at an examination for discovery. They set time limits for when certain steps must be completed. For example, you must serve your notice of civil claim on the other party within 12 months. They ensure that all parties adhere to the same rules, which makes the litigation process fair for everyone. No one can do something or demand that the other party do something, like produce documents for inspection, unless that procedure is defined in the rules. If you look at the table of contents for the rules, you will see that they are listed in the order that your case will probably follow. For example, Part 1 of the rules tells you when to use the rules. Part 2 tells you how to choose the correct way to proceed in court. Part 3 tells you how to start your claim, and so on. If you have a question about the next step when taking your case to court, the Supreme Court rules are the first place that you should look. You will find answers to all your procedural questions. The rules refer to the forms you must complete and file with the court registry to take certain steps in your legal proceeding. The forms are set out in Appendix A to the rules. For example, you would use Form 1, the Notice of Civil Claim, if you start a legal action in the Supreme Court. The rules explain the costs that you or the other party may be ordered to pay after a court application or trial. For example, if the judge ruled entirely in the other party's favor after a trial, you may have to pay a portion of the other party's legal fees. Appendix B of the rules sets out the costs that parties are sometimes ordered to pay. The rules also tell you about court fees. For example, you must pay money to the court registry when you file your documents in court, schedule a trial date, or rent rooms for an examination for discovery. The court fees are set out in Appendix C, Schedule 1 of the Rules of Court. The rules provide a guide to the procedures you will need to follow as your case moves forward in court. And as I mentioned, the rules are listed in the order that your court case will likely follow. To illustrate this point, we will use the example of starting a civil case in Supreme Court. You would start by reading the first few sections of the rules. Rule 3-1 explains that you start your case with a document called a Notice of Civil Claim. Form 1 is a blank Notice of Civil Claim. When you have completed the Notice of Civil Claim, you must file it in the Supreme Court Registry along with a filing fee of $200. Once this is done, the action will be assigned an action number in the top right corner. which you must always include on every document you file with the court in the action. You must then serve the notice of civil claim on the party you are suing. Rule 4-3 tells you how you must do so. If you need to prove service of the document, you must also prepare an affidavit of personal service using Form 15. Typically, you would not need to prove service if the other party files a response to civil claim in the action, but you will need to prove service if they do not file a response. If you, the other party, or the court decides that you should attend a case planning conference, Rule 5-1 tells you how to schedule one. A case planning conference brings the parties together early in the litigation to talk about how the case will proceed. Form 19 is a notice that tells the other party the time and place for the case planning conference. You must file it in the court registry and pay a fee of $80. The procedure for discovery and inspection of the other party's documents is described in Rule 7-1. To prepare a list of your own documents, you would use Form 22. The procedure for examination for discovery of the other party is set out in Rule 7-2. Form 23 is used to advise the other party that he or she is required to attend an examination for discovery to answer questions about the legal dispute. You may make an application to court before trial to get a decision on a pre-trial issue that you and the other party cannot resolve. As an example, you might disagree on whether or not the other party is required to produce certain documents for you to inspect. To make the application, you need to review Rules 8-1 to 8-6. You would use Form 32 to schedule an application before a judge and Form 33 if you are the other party responding to notice of application. There is a fee of $80 for filing a notice of application in the court registry. Remember that whatever you file in the court registry should always be served on the other party. Setting your case for trial is described in Rules 12-1 to 12-6, and you would use Forms 40 to 47. And finally, you can read about court orders in Rule 13-1. To draft an order after trial, you would use Form 48. The fee for filing a notice of trial is $200. This website provides a series of guidebooks for representing yourself in Supreme Court civil matters. They cover a range of topics from providing an overview of the civil litigation process to enforcing court orders. The guidebooks will help you understand court rules and procedures, and they provide information on how to complete the required court forms. Family law procedures are very similar to civil law cases in Supreme Court. Your family law case moves forward until you reach a resolution of your dispute, either by agreement or by having a judge decide the matter in a trial. Read the rules to understand what procedures to follow, and then complete the required court forms to inform the court and the other party what you are doing, why you are taking that step, and what issue you want to resolve. You must use court forms to advance your case in the Supreme Court of BC. There are different court forms for civil, family, and criminal matters. The forms that you need to use in every situation are set out in the court rules. It is very important to familiarize yourself with the forms that you will be using in your case. You cannot create your own form with information that you think is necessary. You must use the forms set out in the rules. There are 3 ways to complete and file court forms. You can print out the form and write in the necessary information. You can do this for any form except a court order. That form cannot be handwritten. Once the form is completed and signed, you can take it to the court registry for filing. You can fill in the form online, open the form document, fill in the blank fields, and save the form with your information on it. Then print out your completed form, sign it, and take it to the court registry for filing. You can fill in the form online, and using the court's e-filing services, you can submit your form online for a small fee. This procedure is more complicated because it requires that you create a secure digital signature. It is normally used by law firms and other regular users of court services. This website provides more information to help you complete Supreme Court forms. For civil law matters, use the guidebooks mentioned earlier, and for many of the forms, you can also watch a brief video or read notes on how to complete the form. To access information on civil forms, click here. For family law matters, Legal Services Society has produced an excellent video on completing family forms, and they also have published a series of help guides. To access this information, click here and then select Court Forms in the right column. In addition, the Court Services branch has produced a helpful how-to guide for civil and family forms. To view this document, click here.